Hi guys, welcome back to my channel. My name is Ksenia and I make videos for people who, like myself, are going through the family immigration process. I'm not an immigration attorney. My videos are based on publicly available information, my own experience, and the experience of my subscribers. And the purpose of my channel is to give you guys the confidence to go through this process completely on your own. I asked for some of the topics that you would like me to cover, and one of the more popular questions that I usually receive has to do with changing your consular application to adjustment of status. So this is what we're going to talk about in today's video. And particularly, I'm talking about family-based applicants just because this is what I know based on experience that many of you have shared with me. Unlike those applicants who initially begin their process with adjustment of status and then need to switch to consulate by filing the form I-824 and having an extra processing time added on top of all the applications. When it comes to doing it the other way around, where you started with consulate and would like to change to adjustment of status, the process is fairly easy. You can simply do so by filing your form I-485. You do not have to file any specific forms in order to be able to transfer your application back from the NVC to USCIS. However, not everyone can do so. It all depends on whether you are eligible to file for adjustment of status in the first place. If you are an immediate relative of a US citizen, meaning if you are a spouse, an unmarried child under the age of 21, or a parent of a US citizen, you are considered an immediate relative, which means that you can apply for adjustment of status at any time. That is, of course, if based on other circumstances of your case, you are eligible to adjust your status. What I mean by that is if you have a legal entry to the United States, you have never violated immigration or any other kinds of laws that might require you to file for any kind of waivers of inadmissibility, etc. So, if considering other circumstances, if you are eligible to file for adjustment of status, you may do so by filing the form I-485, of course, once you are on US soil. However, if you fall under any other type of family preference category, meaning any other relative other than the immediate relative of a US citizen, you will only be able to apply for adjustment of status if a visa is available to you based on your spot in line on the visa bulletin. If you happen to be in the United States and your priority date falls before the priority date that is currently being processed on the visa bulletin, then you may be able to apply for adjustment of status. Like I said earlier, if you know for sure that you are eligible to apply for adjustment of status, you can simply go ahead and file the form I-485. With that form, there comes a list of specific supporting documents that need to be submitted, which are outlined in detail in the form I-485 instructions, as well as a video I made, which I will post in the top right corner right now, talking about supporting documents required for this form. In addition, you will have to include a copy of your I-130 approval notice or I-130 receipt if your I-130 hasn't yet been approved. And you will have to pay associated fees, submit the affidavit of support, and the medical examination, in addition to other forms that may be filed at the same time, such as employment authorization and advance parole document. Even if you have already paid all the necessary fees to the NVC, including the immigrant visa fee, the affidavit of support fee, you still have to pay all the fees associated with I-485, and the fees that you have already paid to the NVC will not be refunded back to you. Basically, you will follow all the same procedures as if you have never initiated the consular process. Another question that I receive is, when switching from consular process to adjustment of status, does it speed up or slow down the case? The act of switching from consular process to adjustment of status doesn't necessarily mean that it will slow down your case. In majority of cases, the processing times depends on, firstly, the processing center that accepts your case, the field office that will then process your case, and the circumstances of your particular case. The processing times listed on the USCIS site are not reliable. They are rough estimates based on the 80% of all cases being processed at this time. Your particular case may be more complicated, or your particular case may be easier for them to process. Again, all you can do at this point is simply be patient and wait. And finally, you will probably continue to receive updates from the NVC. Whether or not you have already paid all the fees and submitted all the applications to them and became documentarily qualified, same applies to those of you who haven't yet completed any applications with the NVC, or maybe you haven't paid the fees yet. The NVC will continue to reach out to you and they will continue to request for you to work on your case. You do not have to continue working on your case if you have already filed for adjustment of status. And the Department of State also posted on their page that if you have initiated the adjustment of status process, please do not continue to pay fees associated with the NVC, meaning the immigrant visa fee and the affidavit of support fees. If, however, you already paid those fees, like I said earlier in this video, they will not be refunded back to you. Although you're not required to notify the NVC about your adjustment of status process, it is a good idea to submit a public inquiry form with the NVC and provide the receipt number for your I-130 petition to let them know that you have started the adjustment of status process so that they can discontinue your consular case. So I hope that you found this video useful. Please let me know if you have any additional questions. Subscribe to this channel if you haven't already, and I hope to see you guys in my next videos. Bye!